हमें आप देखें, आप हमसे ज़्यादा समझते हैं, वकील हैं, यकीनन हम लोगों की अपनी अपनी राय हैं, ठीक है।
मुझे आप
ज़रा सुन लीजिए ना 2 मिनट जी। वो हम अपने, अगर हम एक दूसरे से इत्तेफाक नहीं करेंगे, अलग अलग राय लिख देंगे, ठीक है। मेरे हिसाब से मुनासिब नहीं है कि हम सवाल के तौर पे अपनी राय आपको दें और फिर कोई हम दूसरा जवाब दें। हम सिर्फ सवाल पूछ रहेंगे आपसे, आखिर में आप अपने दलाइल दे दीजिए, हम उसको नोट कर लेते हैं। हमें पसंद नहीं आए तो फिर हम सवाल, इतने पसंद आए शायद सवाल ही ना पूछें, नहीं पसंद आए 2-4 सवाल पूछ लेंगे। अब आप बिस्मिल्लाह कीजिए जी।
Lord, the concept of trichotomy of power is a concept well known to your lordships. The Constitution, what are those provisions which relate to the trichotomy of power, and let us have a look at them. With reference to the Supreme Court, have a look at Article 176, my lord.
जी,
Article 176.
जी जी, पढ़िए।
My lord, Article 176 says, the Supreme Court shall consist of a Chief Justice, to be known as the Chief Justice of Pakistan, and so many other judges as may be determined by Act of Majlis Shura, Parliament, or until so determined as may be fixed by the President. What this article says is that one of the first step is the appointment of the Chief Justice. He is the centrifugal force, he is the linchpin, and once he is appointed and the rest of these members are not appointed, the Supreme Court will be there. And then the judges will be appointed.
Please चलिए ना, don't state the obvious, it's written there. देखिए, this is
आप-
really,
आप-
no,
यही तो
sorry
कि
to
मुझे
say,
अफसोस हो रहा है।
आपको पता है अवाम कितनी पैसे खर्च कर रही है?
सर,
हमने
मैं
ये,
अवाम
आप
की
ऐसी
खिदमत के
ऐसी
लिए-
बातें तो ना करें हजूर।
सर, आप मुझे आर्ग्यू, तो आप एक तरफ कहते हैं आर्ग्यू करें, दूसरी तरफ आप मुझे
आप कह रहे हैं ये आपने पढ़ लिया।
I am interpreting, I am just
Don't
giving
need
your
interpretation of the obvious. Supreme Court comprises of Chief Justice and Judges of the Supreme Court. Obvious.
No, it is not.
अच्छा, it's not.
It is not.
बताइए।
I am giving you, your lordship, a circumstance that let us assume, to understand the dynamic of Article 176, that assume there is a Chief Justice and there is no other judge. The question is, will the Supreme Court come into existence? The answer is
I
yes.
will not answer your question.
It
We are
will.
not
I
here.
am answering.
We
I
are
am
not here in a
answering.
theoretical realm. Please don't. No, now this is
will.
not fair. We are not here in a theoretical realm to
Let us
discuss
proceed.
what may or may not
Let
happen.
us
We are
proceed.
faced with a particular law. You challenge that law. Argue that case.
Let us proceed further, my lord. Let us go to Article 87. Article 87 relates to the Parliament and the Senate. Each house shall have a separate secretariat. Majlis provided that nothing in this clause shall be construed as preventing the creation of posts common to both the houses. Sub-Article 2, Majlis Shura Parliament may by law regulate the recruitment and condition of service of persons appointed to the secretarial staff of either house. Until provision 3, until provision is made by Majlis Shura under clause 2, the Speaker or, as the case may be, the Chairman may, with the approval of the President, make rules regulating the recruitment and conditions of service of person appointed to the secretarial staff of the National Assembly or Senate. So this is the rule-making power. Let's go to Article 67.
I will not allow it, and I might even start imposing costs. Let's go here, let's go there. What's the relevance of Article 187? Don't do this to us. Sorry, please don't do this. Please don't do this.
It shows that the Parliament as a separate organ of the state
Profound.
as the power to make rules for its internal working. And this is the theme which is contained in Article 67.
नो, ये रूल सिर्फ बनाएंगे किसके लिए? सेक्रेटेरिएट
हमने तो नहीं बनाए लिए।
अपॉइंटमेंट के लिए,
Constitution-
रिक्रूटमेंट के लिए और उसके लिए, ये 3 चीजें लिखी हुई हैं साहब।
सर मैं आपको शो ये करना चाह रहा हूँ कि पार्लियामेंट का अलग सेट ऑफ रूल्स है, लेजिस्लेचर एग्जीक्यूटिव का अलग है, सुप्रीम कोर्ट का अलग है, और ये रूल्स जो हैं
आप
ये
सुप्रीम कोर्ट वाले पे आ जाइए ना, हम पार्लियामेंट के रूल्स जब वो चैलेंज करेंगे ना आप कि उन्होंने गलत बनाए वो देख लेंगे। अभी आप सुप्रीम कोर्ट पे आ जाइए बस,
सुप्रीम कोर्ट के रूल्स हैं आर्टिकल 191।
उसकी तशरीह कर दें, खत्म।
ठीक।
Subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, the law is a word which is different from the act of the parliament. It may,
Law is different from act of parliament.
yes, it is. Law is
So
a
this is something I've never heard before.
Yes, sir. Let me allow you to assist you. Law encompasses a lot of other things than the act of the parliament. Law includes with it itself usage having the force of law. Refer to Article 8.
In the same sentence, the parliament Ain has used constitution, law and rules.
Sir.
And please, I'm not going to expect this kind of arguments before the Supreme Court. Sorry, this is not on.
I am
नहीं,
giving
देखिए
your
आप
lord-
ऐसे
no, I'm
arguments ना
giving your
कीजिए।
lordship extraordinarily good argument. If your lordship is inclined to ridicule me like that, I will withdraw from the case. I don't
इम्तियाज साहब,
I don't allow this.
Please, that's your choice.
Your lordship has constantly
इम्तियाज साहब,
thwarted my arguments again and again. Have a patience to hear my arguments.
अच्छा ये बताइए जो बेचारे लोग जेल में पड़े हुए हैं ना,
तो बेचारों को छोड़ दे सर।
छोड़ेंगे नहीं हम,
मैं बेचारा हूँ, मैं ऐसे ही हूँ।
हाँ नहीं,
मैं भी
उनके
नीचे से
cases
track पे
कौन
ऊपर आया।
फैसला करेगा? एक चीज होती है अमेरिकन आइन में, वो लोग करते हैं क्या होता है, फिलिबस्टरिंग, कि जी चलते रहो। अगर आप समझ रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा।
अब आप
अभी आपने मुझे
अब आप बोलने आपको हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं।
सर,
तो
ये
ये
आपकी बात
देखिए,
आधे घंटे से सुन लो सर।
चलें।
if I've got
Sir.
you correctly, if
Sir.
I've got you correctly, you're saying that law is not only the act of the parliament,
Yes.
because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass
My lord,
any law which was contrary to it.
I would not go to that extent. Assume there are no rules. Assume. The question is whether the parliament can frame this law or not is a question which probably is not free from doubt. I would still say the parliament can't do it. Rules are imperative. If your lordship would look at Article 8,
आप फिर ये
if your lordship would look at, if your lordship would look at Article
एक
8.
सेकंड, इम्तियाज साहब,
Sir.
ये सिंपल हो गया है। आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, दिस एक्सक्लूड्स एन इनेक्टमेंट ऑफ द पार्लियामेंट।
No, my lord, I'm not saying this at all. I say law has a larger composition than the act of the parliament.
So we are, at this moment, we are only concerned with an act of the parliament.
Your lordship has asked me a question, what is the scope of the word law? And I'm trying to assist your lordship.
In this case, it's not relevant because the law has already come.
My lord,
Question, आपने सिर्फ
I
बताया
am saying that this law, your lordship's assumption is that since the word law has been used in Article 191, therefore the parliament can make this law. I am trying to show to your lordship it is not the case.
I'll take you back to my original question,
Please, Lordship.
where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law, so how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. there are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.
In essence, the framers of the Constitution were conscious of the distinction between an act of the Parliament and the law. While they envisaged that law includes judge-made law and other variations of the law, Act of Parliament was specifically used in a particular sense, and they can't be used interchangeably.
And whether this enactment, Act of Parliament, cannot be considered as law?
My Lord, in ordinary parlance, there may be impression.
No, I'm talking specifically
but
about this.
Within the context of Article 199,
this is not law.
It is the Constitution and law. It would mean law in a broader context. And what are those? Laws which are protected under Article 270AA. Usage or customary practice having the force of law in terms of Article 8. And judge-made law, the judicial precedents which your lordships have given time to time to the people of Pakistan to show to them what law is.
I got your point. You say that every usage custom can be considered as law, but cannot be considered as Act of the Parliament.
Yes.
Whereas Act of the Parliament can be considered as Act of the Parliament as well as law.
Yes.
So then it is not a law.
I am saying the context in which the word law has been used in the phraseology of Article 191 manifests that this is not an ordinary Act of Parliament. It means the law which has been rendered from time to time in the form of judgments of the superior courts.
Or are you arguing that it is the exclusive power of this court under Article 191 to make rules?
Absolutely.
And those rules, once that power has been exercised, whether by specifically making rules or through law, that is judge-made law, ordinary legislation cannot override that because there is no legislative competence to do that in terms of item 51.
That is precisely my argument. I will go a step further.
Before you do that, that's very interesting. I was just recalling the equivalent provision in the Indian Constitution is Article 145 relating to the rules of the Supreme Court. Now this has very interesting language. It says subject to the provisions of any law made by Parliament.
Yes.
The Supreme Court may from time to time with the approval of the President make rules, etc. So here, in relation to law, they are clarifying it is statute law or made by Parliament. Whereas in our case, it is just law. So the rules, the law includes any decision of the court which sets out the practice and procedure of the court. And to that extent, statute law cannot override it, cannot supplant it, cannot whittle it down until the court itself revisits that law on the judicial side. Maybe it cannot even be done by the full court sitting on the administrative side.
Can't be.
Go back, because there is a certain equivalence between what the court can do on the administrative side to make its rules and what Parliament can do maybe in terms of statute law. But it seems to be that use of, speaking for myself, the use of the word law, which includes case law or judge-made law, even the full court on the administrative side cannot overrule that. So this rule, which is supposedly overruled by sections 2 and 3, master of the roster, that is judge-made law. And therefore, even the full court sitting on the administrative side can't do it unless the court revisits that principle on the judicial side.
Imtiaz Sahab, how will we read into this provision 191? It's a constitutional provision. We'll have to read into it that the law only means judgment law. फिर अगर आपका आर्ग्यूमेंट ले लिया जाए तो इस लॉ एक्सप्रेशन से enactment is excluded, but even a usage or a custom would override a rule made by all of us.
My Lord, my submission is as follows. Allow me just follow your Lordship's consumption. My Lord, the Constitution as I read it, and I make submission with respect to your Lordships, the Supreme Court of Pakistan has held that notwithstanding the rules and the rules which are framed under the constitutional scheme, they are on a higher pedestal than the ordinary law. Even conventions which have been judicially recognized by the superior courts are constitution by themselves, and the parliament cannot encroach upon them.
This
is next point.
इम्तियाज साहब पहले इस फंडामेंटल उसको क्लियर कर दें. Do we have to read into the expression law that it is only confined to the judgments of this court and the precedent law?
Your Lordship will appreciate the contours of the word law, which has been used with reference to the Constitution in terms of Article 181 and the scope of that word. And if your Lordships come to the conclusion that this includes the case law rendered by the superior courts have said that even conventions, if they are proven before the court in the constitutional domain, they are the constitution themselves and violation cannot take place.
ये जो लॉ है आपके ख्याल में 191 में नहीं आता, ये किस कैटेगरी का लॉ है?
ये कैटेगरी सर अनकॉन्स्टिट्यूशनल लॉ है, ये आते ही नहीं है.
In which category you will fall this law, because you
this is act of the
Article 191. The definition of law is something else which you are trying to.
This is an act of the parliament. It comes out of the outer scheme of the word law, and there are other sources of law.
It is out of the word scheme of law. What is your argument on this point?
My argument is that to isolate the word law with reference to act of parliament alone.
What about Article 140 and 141, where is also the word law has been used?
Yes, what I'm saying this is that Article 141 and 142 relate to
article of the Constitution in which the laws are made by the Parliament.
My Lord,
under Article 141, the law is mentioned. If it is not the law, then what is the category of this law?
Lord,
because
Article
we are going
1
to develop a new jurisprudence in this case. The third category of law.
Article 141 has to be read with the fourth schedule, and it cannot be read in isolation. What it means is this, that these are the laws which will be enacted through act of parliament.
No, if you will read Article 142, if you will read Article 142,
सिद्दीकी साहब अगर कॉम्पिटेंस की बात है ना, कॉम्पिटेंस की अगर बात जो बार बार सवाल हो रहा है, तो एंट्री 55 और 59 को पढ़ लें, उसमें तो पावर है ना कि पावर्स लॉ आ सकता है.
सर लॉ एनलार्जमेंट के लिए फॉर एग्जांपल
पढ़े ना, सप्लीमेंटल पावर्स भी दे सकता है.
सर ये सप्लीमेंटल पावर नहीं है,
ये बहस आप
ये इंटरनल वर्किंग को इंटरफियर किया जा रहा है.
तो आप ये बहस करें ना कि ये सप्लीमेंटल पावर्स के अंदर है या नहीं, या एंसिलरी पावर्स के अंदर है कि नहीं. आप तो कह रहे हैं लॉ ही नहीं बना.
सर मैं बताता हूँ, मैं आपसे कह रहा हूँ कि अगर ये लॉ ये हो कि आपको फॉर एग्जांपल इलेक्शन एक्ट के तहत डायरेक्ट अपील दी जा रही है सुप्रीम कोर्ट में, या सर्विस मैटर्स में दी जा रही है, तो वो इनलार्जमेंट ऑफ जुरिसडिक्शन हो सकती है, लेकिन आपकी इंटरनल वर्किंग के अंदर लॉ फ्रेम नहीं हो सकता.
देखिए ना, एक सेकंड, बड़ा सिंपल सा सवाल है, अगर हम फोकस कर लें तो बड़ी जल्दी मामला हल हो सकता है. एक तो ये है कि लॉ इन्विजिज किया 191 ने, तो कानून आइन रिडंडेंट नहीं होता, कुछ चीज़ कानून ऐसा हो सकता है. उसी आइन के अंदर लिखा है कि 55 में सप्लीमेंटल पावर्स दे सकता है, 59 में लिखा है और एंसिलरी मैटर्स भी देख सकता है. अब आपने सिर्फ हमें ये बताना है कि क्या पार्लियामेंट ऐसा कोई कानून बना सकती है 55, 59 और भी शायद एक आध प्रोविजन एंट्री के तहत जो रेगुलेट कर ले अफेयर्स ऑफ द सुप्रीम कोर्ट.
सर
क्योंकि 191 इन्विजिज करता है कि ऐसा कानून हो सकता है, तो सुन लीजिए, तो वो कानून रिडंडेंट तो लफ्ज नहीं हो सकता ना 191 में. एक कानून ऐसा होता है कोई جو ریگولیٹ کرے پروسیجر کو، اس کی پاور 55 اور 59 میں دی ہوئی ہے. آپ کا یہ بحث ہو سکتی ہے کہ سر اس میں سے وہ پاور نہیں نکلتی فیڈرل گورنمنٹ فیڈرل لیجسلیچر کی، وہ آپ بتا دیں ہمیں بس سیدھا.
سر دس item 55 first makes a prohibition.
وہ ہم نے پڑھ لیا. میں آخری
سر
لائن
بھی آپ نے پڑھ لی ہے، میں بھی ساری زندگی I've been rubbing shoulders with your lordship. This creates an impediment on the word jurisdiction and power. اس کے اوپر تو full stop ہے.
اس کو پورا پڑھیے نا ملا کے.
سر
بٹس اینڈ پیسز
سر میں دوبارہ پڑھوں گا تو وہ کہیں گے کہ دوبارہ پڑھ رہے ہیں آپ.
نہیں، اس میں آگے جا
jurisdiction and power of all courts except the Supreme Court. کہ jurisdiction and power پہ نہیں آپ law بنا سکتے.
آگے چلیں.
With respect to any matter in the list and to such extent as is expressly authorized by or under the Constitution, the enlargement of jurisdiction of the Supreme Court. Enlargement ہو سکتی ہے.
آگے
بس
enlargement کے لیے بھی there has to be a specific, یہ جو language used ہے, specific authorization.
Yes.
Now where is the specific authorization?
آگے پڑھیں، اگر آپ سے آگے پڑھیں انلارجمنٹ
And conferring thereon of supplemental powers.
سپلیمنٹل پاورز پارلیمنٹ لگا سکتا ہے، دے سکتا ہے سپریم کورٹ کو.
Supplemental powers یہ ہے کہ آپ کو وہ کہہ سکتا ہے کہ آپ فائنینس سے یہ پیسہ withdraw کر سکتے ہیں، یا آپ یہ لیٹیگنٹ کو کوئی اپیل آئی ہے تو اس پہ یہ ٹکٹ لگا کے پیسہ سپریم کورٹ میں ڈپازٹ ہو سکے. یہ سپلیمنٹل پاورز ہیں. وہ یہ نہیں کہہ سکتے کہ چیف جسٹس صاحب اکیلے فیصلہ نہیں کریں گے، ہم نہیں مانتے اس بات کو.
پاور دے رہے ہیں کہ 4 اور لوگ
نہیں، وہ یہ نہیں کہہ رہے، وہ ریگولیٹ کر رہے ہیں پاور آف دی چیف جسٹس
امتیاز صاحب
ریلیٹنگ ٹو jurisdiction and powers.
دو پیس میں پڑھے نا آپ پلیز. دیکھیے اس کا یہ کانسٹیٹیوشن کا جو اس کا یہ والا انٹرپریٹیشن ہے اس کا, as such extent as is expressly authorized by or under the constitution the enlargement of the jurisdiction of the Supreme Court. ایک اینڈ کے بعد جو ہے نا وہ conferring thereon of supplemental powers. اگر اس کو 191 کے ساتھ آپ ملا کے پڑھتے ہیں تو subject to constitution and law, تو یہ والی جو بات دو حصوں میں ہے, اس کو آپ سپلیمنٹل پاور کو آپ تھوڑی دیر کے لیے الگ بھی کر دیں تو وہ اینڈ ہے, وہ اور نہیں ہے.
یہ کہہ یہ رہا ہے یہ آرٹیکل 191, اگر آپ آرٹیکل 191 کو
سپریم کورٹ پریکٹس اینڈ پروسیجرایکٹ 2023 کے خلاف درخواستوں پر اس وقت سماعت جاری ہے. چیف جسٹس قاضی فائز عیسی کی سربراہی میں فل کورٹ سماعت کر رہا ہے. تاریخ میں پہلی مرتبہ فل کورٹ کی سماعت پی ٹی وی نیوز اور پی ٹی وی نیشنل پر براہ راست نشر کی جا رہی ہے.